Okay, Attorney Bancroft.
Thank you, Your Honor. May it please the court, Allison Bancroft on behalf of Mother, who is also with me in the courtroom today. This court in Vasquez-Diaz held that virtual hearings may satisfy due process if they approximate an in-person hearing and can adequately safeguard a party's right to hear the testimony, to see the witnesses testify against them, to give their testimony, and to privately consult with their attorneys. But the almost ideal video circumstances in Vasquez-Diaz were not the circumstances of this case. What happened in this Zoom trial, which was really only a telephone trial for my client, was a technological disaster, and those errors that occurred at trial deprived her of a fair trial in a case where her rights at stake are so fundamental.
Counsel, can I ask you a question? There was a hearing, a termination proceeding that was vacated.
Yes, Your Honor.
Tell me a little bit about that. What happened there?
In February of 2020, there was a prior termination trial. The judge in that case mistakenly issued a premature decision without hearing the testimony in Mother's case. And as a result, Mother was granted a new trial, and that judge recused himself in March of 2020. And this trial then took place following that. Okay. In this Vasquez-Diaz concurrence, Judge Kafka noted that not all litigants have access to stable, reliable internet or Zoom-ready devices, and not all have enough familiarity with Zoom to fully participate in a virtual hearing. In this case, the trial court moved forward with a Zoom trial over Pro Se Mother's objection, knowing that Pro Se Mother only had a cell phone with no access to video, and knowing that her audio was terribly flawed. There were no pretrial safeguards that took place in this trial to ensure that Mother had access to any of those things that are necessary, such as a laptop, a desktop, reliable internet.
Before we go through that, one other question, and that is that the judge made some findings about the Mother hanging up. Are you saying those are clearly erroneous?
Yes, Your Honor. And before I discuss the myriad of ways that Mother was denied through the technology issues at trial, I would like to discuss the judge's clearly erroneous findings that Mother chose to absent herself during this trial. First, in the case summary by the judge, it's on Record Appendix at page 56, the judge sets out Mother's behavior during trial and then echoes that in his conclusion of law number 22. And he states that Mother hung up on the first day of trial, that he took a negative inference against her, and that she rejoined. In the conclusion, he states that she disconnected during the first day. And that finding is clearly erroneous. It's clear from the transcript that what happened on the first day of trial was that Mother was connected throughout the testimony of that first witness, that the judge was unable to hear her at the time when it came for cross-examination, and the judge removed her, noting that he was assuming it was a technical issue and stating on the record that he did not know if Mother's absence was purposeful. To the extent that he could have believed that that issue was related to Mother's telephone as opposed to the Zoom connection of the court, immediately, as soon as the second witness started to testify, the exact same issue occurred during the testimony of the second witness. The second witness was connected. The court noticed that it was unable to hear her. The court removed her from the Zoom feed, and she was able to rejoin. The court then took the testimony of a third witness. There was an issue with Zoom during her testimony. The court removed her. She was unable to rejoin, and then had to call in from another device. From the judge's clearly erroneous findings, and I set them out in detail in my brief, but the judge then took a number of negative inferences in which he stated that Mother refused to testify and that Mother refused to cross-examine witnesses. The judge abused his discretion.
But we do have day number 2 when she clearly says, a pox on your house, it's over, right?
On day number 2, there was an instance in which mother announced that she was done with the proceeding, hung up. And I would say that in juvenile court cases, it does sometimes occur that parents do walk out of the courtroom, very emotional, very upset. They're able to gather themselves.
No,
and
no,
come
I
right
get
back.
your argument, and you've laid it out well as far as the factual findings and your argument that it's clearly erroneous. The factual foundation for her being unable to connect all come in the affidavit for motion for new trial, correct?
No. So there are the Zoom issues. Mother's connection issues are on the record. There was a problem on the second day of trial when mother first connected with the court. It wasn't transcribed, and so that had to be reconstructed. It's in the record appendix at pages 162. And mother immediately, when she came back on the second day, she explained to the court that she had service. She had really bad service on the first day of trial. She also told the judge that she wasn't able to hear the entire testimony of the first witness.
Okay, so because I guess the point I was trying to make was that she files a motion for new trial with the factual basis for it, and the judge just denies it the same day. There's no factual findings to say otherwise, correct?
That is correct. He did issue his findings in the case approximately a week or two later, but there were no findings on the mother's new trial, which included an affidavit with additional information about her lack of service issues.
Are you done?
Yeah, I am, thank you.
So in September of 2020, right, this is when the trial's taking place. What, the courts are closed, right, at this point?
Yes.
What are they doing out there? Because we've got kids. I understand that there are all kinds of problems with this trial. I get it. But an in-person trial wasn't possible then, right? The courts are closed. Is that correct?
That is correct.
So given we're acting in the best interest of the child, what should have happened? I understand you don't like this and there are good reasons not to like it, but tell me what should have happened given this thing has been going on a long time. The child's 10, right, at this point?
The child's 11 today.
Today.
So,
Is the child, okay, so the
Yes.
child, tell me what should have happened.
so there are a number of things which could have happened. Essentially, the motion for an in-person trial was a motion to continue trial until such time as it could be in person. If the judge...
So we had a similar to Vasquez, a request for a continuance here. Because in Vasquez, there's a request for a continuance, it's denied, right? If I'm
Right.
remembering it correctly.
And so this was titled a motion for an in-person trial, but because it was an impossibility, it could have been treated like her prior motion was, as a motion to continue until such a time as it could be conducted. There are always concerns about the child's best interests and the need for permanency, and those interests could have been satisfied while also affording mother her due process by doing a number of things. The first would have been allowing mother a short recess to try to get the technology necessary in order to participate on video during the Zoom trial, so she didn't have to do it over the telephone.
Was that given an option to the judge?
I'm sorry?
Did she give this as an option to the judge?
She didn't. The court knew at the beginning of trial that she only had telephone access, and the court does have a responsibility in order to facilitate meaningful participation. And in this case, mother argues that her due process would have been facilitated had she been able to use all of the functions of Zoom, like the other parties. And particularly in this case where she was pro se, she should have been able to see the witnesses testify against her.
And I'm sorry for not knowing the record better, but did she say, hey, give me an hour and I'll grab a laptop?
She did not say that, and truthfully, given her indigent status, she didn't have any options.
Okay, so when you're saying the judge should have done this, it really kind of rings hollow because those really weren't options to the judge, right?
Well, what I'm saying is that the judge should have recognized that this was an issue and made an inquiry to determine whether or not there was some way that she could participate via video before proceeding directly to the trial with mother over the telephone. But there are other ways.
Some courts have Zoom rooms. I don't know if they had them back then, but there's an opportunity to be able to not be in the courtroom, separated, but still participate by Zoom. Did that exist at this time?
I don't know if that existed at this courthouse. It certainly wasn't an option that was given to mother. And everything was closed at the time. The public libraries were closed. She had no way to obtain the technology that she needed. But again,
Was any of this discussed? I mean, I haven't read the transcripts of this, but when this is going on, and clearly she can't hear or whatever, was there and she's got standby counsel, right?
She does.
Standby counsel is on the video. Is there any discussion of, okay, we have to do something here? Or basically just get her back on the phone was the discussion?
Right. Standby counsel alerted the court that she didn't have video capacity. Other than that, standby counsel was there for mother if mother had questions, and mother wasn't able to access standby counsel at all during the trial.
Wait, was there a point in time where she wanted to do that and was not given the opportunity to do that, to access her standby counsel?
Well, the point that I'm trying to make is that if there was, she had no opportunity. The only device she had was her cell phone. She was listening to the trial on her cell phone. And the court in Vasquez-Diaz, when they talk about those parts of Zoom that safeguard someone's due process rights, they include the fact that there's a breakout room. So if you have a question for your attorney or your standby counsel, you'd have the ability to do so. And mother didn't have, because of her access point, she had none of the capabilities of Zoom or any of those protections that would be afforded to Zoom that would approximate an in-person trial. But getting back to Judge Kafker's question about what else the court could have done in order to keep this trial moving and preserve mother's due process rights, certainly at the time where the judge discovered that mother couldn't be heard, instead of simply moving forward with the other two witnesses, he could have stopped the trial at that time, put those two witnesses over to the following day instead of taking their testimony, knowing that there was an issue about the technology.
Didn't he give the mom an opportunity to recall these witnesses?
On the second
On the second day?
On the second day of trial, after mother explained her issues, he told her that she had the opportunity to cross-examine them.
Right.
But he knew she hadn't heard most of the first witness, and she had heard none of the second or third witness because he had removed her. So the opportunity to cross-examine witnesses whose testimony you have not heard on direct is largely...
Well, he had removed her because of her misconduct, correct?
No, Your Honor. He had removed her because he couldn't hear her response when he asked her to cross-examine the first witness. That was a Zoom-related issue.
That's day one, I'm sorry.
Day one.
Yeah, I'm confusing
Yes.
day one and day two.
Right.
In terms of the timeliness, I noticed the decision doesn't get issued until June of 2021, right? So we have a hearing in September. I take it the main reason for doing this is timing. Does the judge dispense with consent at the trial and then just doesn't issue the decision for 9 months or whatever it is? Or is there no decision whatsoever in this case until June of 2021?
So if I understand your question, he issued a termination decree immediately after?
Did it immediately after, okay.
Right, so soon thereafter. But the findings of facts didn't issue until the following summer.
Right. And I take it this child's pre-adoptive home is still in place. I'll ask the child that. Is that?
It's my understanding that that's so, but it's certainly a question better answered by child's counsel. I see...
The child is 11 years old now?
Yes, she is, Your Honor.
And this had gone on for, I can't remember, she's fired, you've managed to stay hired, but your client has fired 6 or 7 lawyers in between. Is that delaying the trial proceedings here?
No.
Go ahead, sorry.
No, Your Honor, mother did have a number of prior attorneys. 2 of them, to my knowledge, became judges. One was allowed to withdraw because she became a judge, and one, it was shortly thereafter. There were 3 attorneys who had filed a notice of appearance and then only were attorney of record for a month or 2. So there were really only a few attorneys who actually substantively represented mother.
Okay, any other questions?
No, thanks.
Thank you.
Thank you, Your Honor.
Okay, next we have Attorney Krasner.
May it please the court, Sherry Krasner on behalf of the child. As an attorney who devotes a significant portion of my practice to child welfare appeals, I look forward to a post-pandemic world and guidance from this court as to how in such a world virtual trials can be conducted that afford all the litigants due process. But that's not how I'm here today. I'm here on behalf of one child, a child who is currently 11 years old, came into custody of DCF when she was 4 years old, and remains in the temporary custody of DCF today, 7 years later. It's also a child who, it's very clear on the record, has desired permanency and stability. As far back as October of 2018, even though she was only 8 years old, the guardian ad litem found that she articulated a clear and intelligent and persuasive reasons for no longer wanting to have any contact or visits with her mother. And the record here also makes it clear that these proceedings could have and should have ended sometime after October 14th of 2020. And that is because a pro se litigant, failed to timely file her notice of appeal within the 30-day period. Mother was pro se. There's no doubt that mother was pro se, and cases make it clear that the obligations on a pro se litigant to follow the rules of the court exist. This court said it in the rescript opinion of Briscoe in 2019, relying on older precedents about the obligations of a pro se litigant.
I don't remember, but do we have orders in play at this time delaying when appeals have, do we have whatever the SJC COVID orders in play at this point that would have extended those timeframes?
There was no tolling. Are you suggesting that because of the pandemic that there was some sort of tolling?
Well, we've issued a bunch of orders. I don't know what the status was in September of 2020.
Those were not in effect, or they certainly didn't affect this case. Mother, the decision issued on September 14th of 2020, and mother as a pro se litigant had until October 14th of 2020 to file her notice of appeal. She did not. Her standby counsel, and we have nothing on this record to indicate that mother directed her standby counsel to take that job on her behalf. It was nothing other than simple oversight.
So you're arguing that it was the judge abused his discretion in finding excusable neglect?
There was no excusable neglect. And because there was no excusable neglect, the judge's discretion to allow the late filing and to act on the motion to strike the late filing, it just doesn't exist. Even the cases cited—
Be careful what you wish for, Ms. Krasner. Given what you do, this is a little odd to, having listened to you for 20—
I'm sorry, I can't hear you.
Having listened to you for 20 years, I'm a little surprised by this one, to be honest. I could see your sister over there presenting this, but be careful what you wish for, that's all I'm telling you.
Just representing her client.
It is true. I've been before this court for a long time. I represent parents, and I want parents to be afforded every protection that they are afforded, but that protection is cabined by the rules. It is.
Can I ask you about that protection for the parents bit? Why wasn't the right thing to do, the required thing to do under due process after the judge realized, I can't hear mom, I've bounced her off, standby counsel's trying to get her, can't get her back, why isn't the right thing to do at that point to just adjourn? Why go forward with two other witnesses? And, you know, it just seems inconsistent with due process to me to say, well, we have no idea why mom's not here. It looks like a technical difficulty. Why not just adjourn and say, let's try again on Tuesday?
But that is essentially what the judge did here.
But did he go forward with the second witness and then a third witness, each of whom had technical issues as well?
But he kept saying that first, counsel for DCF asked that a negative inference be drawn against mother. The judge refused to do that.
Right.
He repeated several times that he was going to afford mother the opportunity to recall any witness. And that second day of trial existed so that mother could appear. DCF was prepared to rest its case on that Wednesday, and the only reason that there was, in fact, a hearing on that Friday and a summons issued for mother's appearance, which went to a wrong address because mother hadn't provided the court with the correct address, which is another issue that goes to her rights to appeal. But that second day existed for mother to be able to...
Isn't that a big difference, though? That mom can recall the witnesses, but mom can't cross-examine, so she doesn't know what they said.
Perhaps if this was a case in which mother did not have standby counsel, then that, I think that argument may have been more palatable. But in her brief, mother argues that the court...
Standby counsel didn't question, standby counsel was sort of told to stand down, right?
Right.
Standby counsel didn't ask any questions, didn't step in, just told her she was not on the phone, right?
But there was no question that standby counsel, excuse me, was connected for the entire time. And even in her brief, mother argues that the court could have allowed mother to watch any recorded testimony she missed and then recall witnesses as necessary. And essentially, that is what existed because of standby counsel who was there.
But hold on for 1 second. We're in the middle of this pandemic, and certainly one of the things that we talked about in Vasquez-Diaz was talking about whether or not we really had to go forward. All of these witnesses were witnesses that worked for the department. They weren't precipient witnesses. They could have been called at any time. What we're talking about here was determination of a person's parental rights. Probably the most personal thing and the most heartbreaking thing that anybody could probably go through. Back to Justice Wendland's point. When I'm looking at the transcript, everything that militates in favor of suspension is there. In fact, the judge even says, I'm probably creating an appealable issue here, right? He says, I hate this, right? The clerk's talking about how much they hate it. The judge is talking about how much they hate it. No one can hear anybody. The judge keeps telling the witnesses that are on come in, I can't hear you. Lean in forward. Everyone's having difficulty hearing everybody. And yet it's just okay that the parent isn't there and that no one knows why?
Several things. Absolutely, the parents' rights predominate. They do, but these are trials about the best interest of the child.
Sure.
In September of 2020.
And in September of 2020, the child had just been put in their pre-adoptive home, was doing what, in August, it was in August of that month, wasn't it?
No, it was in August of 2018.
2 years.
Well, but she was in the pre-adoptive home for 2 years, and that wasn't going to change, right?
But it is a pre-adoptive home, underscoring that.
But the point is, the status quo was not going to change with the continuance. That's the point, right?
The child would still not have permanency and stability, and this was a child old enough, perhaps if we're talking about a 3-year-old child who's still living in the same home, doesn't know the intricacies of what it is to be adopted versus to be in a pre-adoptive home. This was a child who was 10 years old, who had refused to see her mother for 2 years, considered to be a knowing refusal.
Sure.
Knew there are findings of fact about the mother coming to homes in the community and saying, my daughter has been stolen. This was not an infant in a home.
But I'm not asking this esoterically. I'm weighing this in terms of whether or not there's a due process violation here. So I'm saying, what is the governmental interest when she's been in the pre-adoptive home for 2 years? All of the witnesses work for the department and easily could, one had left and gone to work for, I think, the city of Malden or something. So what is the governmental interest in pressing forward under these circumstances?
But mother at this trial did not make this request. At the beginning of the trial, mother asked for an in-person trial, and the court said, we're not doing in-person trials now. Mother did not object. On the following, and then mother participated.
Well, she did object. She objected.
I'm sorry, Your Honor?
She did object. She didn't want, she wanted an in-person
She said, but
trial.
when the judge said, I'm denying your motion, we're not doing in-person trials, she just accepted that and went forward with the trial. She didn't say,
Well,
I'm hanging up now because I don't want
should have-
in-person.
She
I
should
only
have
want
done
an
more.
in-person trial.
I'm not even sure a lawyer would have done more, right? I object, Your Honor. Note the record, right? I mean,
A lawyer certainly would have preserved that, that issue.
More formally, that's all. Yeah.
But I see my time is running out. I asked the court to read those 141 findings of fact, and the only ones that mother objects to are ones that go to credibility. That's something clearly within the purview of the trial judge. I asked the court also to think about those findings in the aggregate and about mother's propensity for violence, mother's failure to follow her service plan, and all of those things, whether they add up and what would be in the best interest of the child. And I go back to my first argument that mother did not timely file her notice and that we shouldn't even be here today. And I would ask the court to issue an order of dismissal, and if the court doesn't do that, to act as promptly as it can to afford this child stability. Thank you.
Thank you. Okay, Attorney Murphy.
Good afternoon. May it please the court, Lynn Murphy for the Department of Children and Families. Since mother was given an opportunity to participate in the proceedings, we do not have a due process violation.
Was she afforded the opportunity to meaningfully participate? Forget just participate, meaningfully participate.
Yes, I believe she was.
How? I mean, with everything that we know about what happened here, she didn't have any video access. She's only on the phone. Most of the testimony comes in and no one even realizes that she has been disconnected. At some point, and I've really dug into the transcript, they find out that she's not on, no one can get a hold of her, and rather than stop, everything keeps going. How is that meaningful participation? This is the first day. How is that meaningful participation?
Because the judge on day 2 made efforts, made efforts to give mother another opportunity. And in fact, even though she acted to hang up in such an abrupt manner, the judge, you can see from the transcript, said,
On day 2?
On day 2,
Okay.
I'm going to give mother another opportunity.
Sure, she comes back
I want to recall
in.
witnesses. We will recall witnesses. We will do what it takes to provide her an opportunity to continue to participate. And mother did participate. She did, for a short period, cross-examine the department's social worker. And then at that point, she said, I don't want to question anyone else. So at that point, there was really nothing more for the judge to do. And mother was disinterested in proceeding.
Well, you overlay disinterest in this, and I don't. I just wonder again, you have someone who's not a lawyer, who's surrounded by lawyers and a judge, who quite clearly is giving the indication that I'm just going to give you an opportunity to do something in a vacuum. She hasn't heard anybody from day 1, witness 2 or 3, and who knows how much of witness 1. If you as a lawyer were coming into that day 2 and the judge were to say to you, I'll give you an opportunity to recall or cross-examine these people, we'd be jumping up and down saying that's absolutely unfair because I don't know anything about what those people said 2 days ago. You and I both know that. We both know that. So now somebody who has no legal training whatsoever, who's facing the loss of her child, now under those circumstances, we're supposed to say that that's a meaningful opportunity?
And again, I think she was provided with a meaningful opportunity, but she did not avail herself of those opportunities. She should have said to the judge, I did not hear. In fact, she said the opposite. She said, I had to listen to this badgering all day Wednesday. So we know she did hear something. And she should have been more articulate and said, this is what I need to, I did not hear these other two social workers, and I need to talk to my standby counsel. I need some assistance in this.
Was there any obligation on the judge to ask any further questions of her at some point? Like, have you heard everything you need to hear? You don't want to hear any more from Wednesday, so you terminated, but what would make it able for you to participate today? Did he have any obligation to ask any of those points that Justice Georges is raising?
Well, I think the judge did make efforts throughout the 2 days to involve mother. He was very concerned about this. He kept asking standby counsel, have you had communications with your client? And the counsel said, yes, she can call me and text me. And in fact, she did do that. During the hearing, we did see mother reaching out. And the judge interrupted the proceedings on day 1 and tried different methods. Let's put her in the waiting room. Let's disconnect her. Let's give her 30 minutes. After lunch, the judge says again, okay, has anybody heard? Have you heard counsel from your client? No, nothing. So, and even then...
It's a little bit like having a wedding without the bride, though. I mean, the whole thing seems... I mean, I understand there's some issue. I mean, this is not how we want to do these things, right? Even during the pandemic. This is not Vasquez. This is a mess. I mean, do you have some... Maybe there's some harmless error or burden post that may save you here, but we really don't want to say this is adequate, right? The way this was done is there's just too many problems with it. I mean, I'm very sympathetic to the fact that this child has now been in this home for 5 years, and the trauma that could come from having to redo this. And I don't know well, are there any cases which says the obligation in this kind of procedural mess, is there any harmless error analysis? Because this mother has a lot of problems that have been identified in this record. But at the same time, we can't judge this fully because we haven't had a normal trial. I mean, I don't know how we get out of that box.
Well, I think the circumstances were very challenging. And mother was out of state at the time. I mean, almost every conceivable situation unfortunately happened. And you do have technical problems, but that is on a spectrum. Sometimes you have a little, for a better term, glitch. And there were glitches
but this isn't in the glitch category. This is like gobbledygook category. She's on the phone and every other person is on the video, which in and of itself is a disadvantage. Then she's in and out. Your sister has made a bunch of arguments about factual errors. I don't know if you're going to want to address those, but the judge doesn't seem to have completely recounted the facts correctly. So we've got errors on the factual stuff. This is just, I don't know, can we really save this? And do you want to save this kind of proceeding?
Well, I don't think the judge made any factual errors as to mother's participation. I think the judge acted within his discretion to find that she did terminate, and her activities
the first day, again, she's done a very detailed job. Unlike Justice George, I haven't read this whole transcript yet. Are we going to find that the judge's recounting of the facts on whether she was intentionally terminating or not on the first day is correct? Are we going to find errors there too?
I'm so sorry, I didn't understand the question.
I apologize. Talking through the mask is the problem. Okay, are you confident that her clearly erroneous arguments are going to go out the window too? when we read this transcript? Because it doesn't sound like the judge accurately described when she was sort of intentionally not participating and when she was just cut off.
I think what happened on day one, that the judge suspected that mother was not participating, but held off on making that determination until it became abundantly clear that mother did just disconnect in an abrupt and angry manner. And I think if that had not happened.
On day one or two?
Day two, but then.
But is that, can you then impute that conduct on day two to day one?
I think you can, particularly as the judge found when mother made no efforts to call her counsel even after the hearing elapsed. And the judge had inquired on that on day two. And counsel said, no, I have not heard from mother until today.
I think the problem with that is, as counsel pointed out, the factual findings that were clearly erroneous. I agree with you. If we just went by the trial record, the judge says, I don't believe her. She's rude. She's cutting me off. She's saying, whatever she said on the second day. So I find that on the first day, it's more of the same. But when the judge does that, he makes factual errors. That's a huge problem.
I'm sorry, I didn't hear the last part.
The judge makes factual errors in that regard. That's a problem.
Factual errors into what occurred on day one and day two.
Right, as to her, yeah.
Well, again, I think that the court did not abuse its discretion in finding that mother disconnected on both days.
But the findings aren't put in context of the fact that there are other technical difficulties day one.
But the other technical difficulties were conquered. I think that is another piece of it. Day one, there were technical difficulties with the social worker. I think it was the second or the third. And they were able to overcome those. And this is what I was trying to make my point about.
They weren't able to overcome it. She was. Because she couldn't reconnect and she had to call in. And that's in the transcript.
Right.
So it wasn't as if somehow the clerk and everybody was able to figure all this out. They actually weren't.
Well, I disagree slightly because I think the judge and the clerk tried very hard through the proceedings. They tried different methods to get people connected. And they would move people to the waiting room, disconnect them in order to give them the signal that they were not being heard. So I do believe the judge made great efforts here. Now, I will say that in Vasquez-Diaz, the Superior Court judge did a really good job of giving instructions prior to the hearing and laying out, but if you're disconnected, this is what you should do, and I think that would have been helpful here. But also, given the circumstances, I'm not sure that it would have made any difference because we do have a parent who has anger management issues. In fact, this was a significant part of her parental unfitness.
That wouldn't make any difference point. How does that fit into the doctrine? Is there a harmless error analysis that goes into this? We're determining whether or not there was a constitutional violation. Do we look beyond that? You used the word, it wouldn't have made any difference here. Does that, say you're right, does that factor into our analysis in this type of case?
Yes, I think so, because and the judge did clearly consider mother's history in regards to that.
It wouldn't make any difference if she was an unwilling participant all the way through, correct?
She was unwilling to participate at times, and then at other times she did appear she wanted to participate. I think that's what makes it a little more difficult. It's not, because she would terminate and then come back, and at one point the judge says, well, this...
And believe me, this judge was dealt a bad hand, so I think our comments, obviously we were talking about due process violations, but he was dealt a very bad hand. He did not have the resources or the ability that the Superior Court judge had in Vasquez-Diaz for a better hearing. So let's just put that out on the table as well.
Right, well, that is why I think guidance from this court would certainly be
Well, we
helpful.
hope we're not here again doing this, so we'll see.
Were there a lot of these cases being done by telephone during this time period?
They all were, right?
Well, I would hope not. I mean, and this was 6 months into the pandemic, and I think people really were trying to, find their way through it. And it was unfortunate that Mother only had the telephonic connection. But as we know from adoption of Edmund, that we have had situations where the telephone has had to
That was
suffice.
before Zoom, right?
It
That-
was before Zoom.
Well before Zoom adoption. I take it the prisoners are doing them on Zoom these days rather than by phone, but I don't know
Right,
the answer to that.
Probably,
Yeah.
probably. But if there are no further questions, I would ask you respectfully to affirm and rest on my brief.